Good morning, everyone. This is Ankita again. I work here at the Washington State Coalition Against Domestic Violence, the Crossing Borders Project, and we wanted to bring this material to you in partnership with Lee Hoffheimer and Stacy from WSCADV through their Enlace project, and they are working collaboratively with the Washington State Department of Health. And one of the things that Lee and I were talking about was how the domestic violence and the sexual violence coalitions have overlapping geographical areas that we work in, how we are impacting the same communities, and how we are just looking at, you know, the unique perspectives of our two projects, the Enlace project and the Crossing Borders project, to really look at how we can improve advocacy for Latinas, for pregnant and parenting teens, and for domestic violence and sexual violence survivors. And together, we have this unique opportunity to work with Vanessa Hernandez from the ACLU on the topic of advocating for the education rights of immigrant students. And we met with Vanessa a few times, and I just have been so overjoyed with all the new material and content that I was personally learning. And so I'm hoping that it's going to be equally beneficial, if not more beneficial, to you all. So just before I turn it over to Vanessa, just a couple of logistical things over here. Um, First, this webinar is recorded so that there were many people who could not make this webinar and were really excited about the topic. So we will be recording this webinar. The second thing is the PowerPoint presentation that Vanessa is going to go through. You can download it if you look at the handout section. Like, all you have to do is click on it, save it to your hard drive, and you will have the presentation handy with you if you want to follow along that way. And then finally, we have built in some time for answering your questions, and the way you can ask your questions is typing it into the question box. So when you type in your questions about something you don't understand, depending on the relevancy, I might have Vanessa pause, or I'll just collect all your questions and then read them out loud, and Vanessa will stop and answer all your questions. So I just wanted to go over that and hand it over to Vanessa. So Vanessa, thank you for being here, and you can take it away from here.
All right, thank you, everybody. I am excited to present to you today. My name is Vanessa Hernandez. I am the Youth Policy Director with the ACLU of Washington. And before I get started on the content, I wanted to give you a really quick introduction to myself and to the ACLU. So the ACLU is the American Civil Liberties Union of Washington. We are a nonprofit civil rights organization, and we work on really a broad array of issues, everything from criminal justice reform to racial and gender equality to privacy issues. And though we are generally most known for filing cases in courts, the ACLU also uses a lot of other tools, including community education and litigation and legislative and policy work. I direct the youth policy program at the ACLU, which means that I work on both education and juvenile justice issues. And if I had to sort of summarize the focus of the work, it's really to promote equal access to high quality education for all students, and to challenge policies that push children out of education and into prisons and jails. I am also an attorney. I am a former public school teacher with a master's in education, and I am a parent to two elementary school aged public school kids. With that, on content, I picked for this webinar 4 topics that impact immigrant or migrant students in the education field. Some of these topics, like school discipline, pregnant and parenting, and homelessness, are issues that also affect other students, but as we'll go through, they're ones that disproportionately impact students of color and immigrant students. For each of these topics, I'm going to try to give you a 20 to 30 minute overview of what the issues are, what individual student rights and responsibilities are in this area, provide explanations of ways that advocates can help people navigate these systems, and give you the opportunity after each section to ask questions. So as Ankita said, if you have questions during the presentation, please do write them in on chat. When I'm doing live presentations, I encourage people to interrupt me. I really very much welcome questions. So on that note, turning to our first topic is going to be school discipline. Now, a bit of defining terms here. When I talk about discipline, I'm not talking about a teacher in a classroom saying, Jimmy, make sure that you're focused on your work, right? What I'm really talking about is what advocates call exclusionary school discipline. That means suspension or expulsion, kids being disciplined for their behavior by being removed from school. And there are 3 different levels of exclusionary discipline in Washington, and I'll use these terms sometimes interchangeably. There is short-term suspension, which is a kid being removed from school for any period lower than 10 days. There's long-term suspension, which is a child being removed from school for a set period more than 10 days. And then there is expulsion, which is when the child is actually removed from school for a period of up to 1 full year. And a child who has been expelled doesn't have the automatic right to return to school. This, to me, school discipline is a civil rights issue. And, generally schools have pretty wide latitude to set standards for behavior and to help kids achieve those standards or force children to achieve those standards. But the law is also really clear in Washington that children have a fundamental right to education. And this is actually sort of uncommon. Not every state in the country has this. But in Washington state, our Constitution says very, very clearly that it is the paramount duty of the state to make ample provision for the education of all children within its borders. And then I've underlined these words, without distinction or preference on account of race, color, caste, or sex. So there's 2 really important takeaways from this part of our Constitution. First is that education is the paramount duty of the state. So that basically means educating our children is Washington State's most important job. It is the #1 job of our state. It comes before everything else. What's also important to take away from this part of our state constitution is that even as far back as 1889, Washington lawmakers recognized that education, in order to be valuable, must be equal, and it has to be provided equally to children of all races, to children of all genders, to children regardless of their backgrounds. Unfortunately, that sort of lofty goal, right, that we will provide an equal and amazing education to all students, is often undermined by school discipline practices. And what's even more unfortunate and more scary to me as an advocate is that in the past 30 years or so, not only are children being routinely denied access to education because of their behavior, but oftentimes schools are now acting as a funnel towards the juvenile and adult criminal justice systems. So kids are being affirmatively pushed out of schools and pushed into prisons and jails. That's a phenomenon that advocates call the school to prison pipeline. And rather than have me talk about it, I thought I'd show you this nifty little infographic that was put together by the Marshall Project to explain the phenomenon and give sort of an overview of the national landscape here.
The school to prison pipeline. It's a term that describes how American kids get pushed out of public schools and into the juvenile and criminal justice systems. Basically, harsh zero-tolerance policies in schools have led to more suspensions, expulsions, and even in-school arrests. Getting suspended or expelled means more time away from school, and it doesn't take an honor student to figure out that's bad news. In fact, expelled and suspended students are more likely to get held back a grade, end up in juvie, or just drop out altogether. And dropping out of high school makes you 3 times more likely to get arrested. Back in school, forget about hallway monitors. Students these days often have to deal with school police. Minor offenses that might have landed you in the principal's office back in the day can now actually lead to your arrest. Students of color and those with disabilities are disproportionately affected. Black students get expelled 3 times more than their white classmates, while a student with a disability is 2 times more likely to get an out-of-school suspension than everyone else. And it's not because these kids are just bad apples. The Justice Department found that Black students got harsher punishments than their white peers for doing the same things. So maybe it's time our education system got schooled?
Okay, so a few notes on that particular video. Nationwide, what we see is that not only are discipline rates, suspension and expulsion rates on the rise, but increasingly those discipline practices are being applied sort of in a zero tolerance fashion, meaning any incident of misbehavior, whether it is a too many tardies or insubordination or any possession of contraband on school property, will automatically, no matter what the circumstances, lead to suspension and expulsion. What's also unfortunate is that students of color are disproportionately disciplined. They are disproportionately suspended and expelled, and the same is true for students with disabilities who receive special education services or services under 504. And all of that acting together often leads to children being left back in school, not succeeding academically, and more likely to end up in the criminal justice system. So all of that is bad, right? But as a lawyer, oftentimes the question I get asked is, well, so is that illegal, right? Is it illegal for a school to have discipline policies that result in some groups of students being more likely to be suspended or expelled than others? And in true lawyer fashion, the answer is, it depends. Now, the U.S. Department of Justice and the U.S. Department of Education, and also our state agencies that enforce education and civil rights laws, have all pretty much agreed that student discipline can result in unlawful discrimination in 2 different kinds of ways. The 2 different sorts of discrimination that can apply in this context are disparate treatment and disparate impact. These are super lawyery concepts, and so I'm going to spend a little bit of time explaining them. So disparate treatment, I think, is what most people think of when you think of discrimination. It is intentional, and it is applying different criteria to people based on their membership in a particular group. So different criteria based on race, different criteria based on gender, different criteria based on sexual orientation. So an example of that in the school context is actually a terrible case that the ACLU filed in South Dakota a few years ago. What happened in that case, it was brought on behalf of groups of Native American students in a small district in South Dakota. And the Native students presented a lot of evidence that they were getting suspended and expelled for behaviors that white students were not getting suspended and expelled for. So for example, if 2 children got into a fight, one of them was Native American and one of them was white, only the Native student would get suspended. That is disparate treatment. That is treating people differently specifically because of their race. Disparate impact is a little more complicated than that. Because disparate impact focuses not on the intentions of the person or people involved. Instead, it focuses on the impact of a policy that is applied to all groups. And what disparate impact focuses on is sort of three questions. Does the policy or practice have a harsher impact on one group than another? Is there a good reason why that policy or practice is there? And is there a less discriminatory alternative? Is there some other way that you could accomplish your same goal with a policy that wouldn't have that kind of different impact on, or particular impact on particular groups? So let me give you an example of that. The clearest examples of these are always in the employment context. So let's imagine you're all hiring gym teachers, right? If a school district had a policy that said, we are only going to hire gym teachers who are 5'10" or taller, that is on its face, a neutral policy, right? It doesn't say we're discriminating on the basis of gender. It doesn't say we're discriminating on the basis of race. Everybody has to be 5'10". But the impact of that policy would very clearly be more harsh on women than it would be on men, right? Because there are in the population comparatively fewer women who are taller than 5'10" and comparatively more men. So the effect of that policy is going to be to screen out the vast majority of women. So it is a neutral policy that has a harsher impact on women than men. So then the question is, well, is there a good reason why your gym teacher has to be 5'10"? And if a school district were to say, for example, well, yeah, we want our gym teachers to be able to teach kids, how to play basketball well, and you can only do that well when you're 5'10", the question then becomes, is there a less discriminatory alternative? Could you figure out another way to determine whether people are good at teaching basketball than giving them a height test? And the answer is, of course, yeah, you can give them a test on how well they teach basketball, right? Muggsy Bogues was 5'6", and he was a pro basketball player. So short people can play basketball too. So that's an example of disparate impact. If you have a policy that may seem neutral, but that disproportionately punishes or hurts one group, then you have to be pushed to say, well, why do you have these disproportionalities? Why do you have this policy? And is there a less discriminatory way you can accomplish whatever legitimate goals you might have? Now, increasingly, people are coming to recognize that school discipline policies, both statewide, nationwide, and at individual districts, have disproportionate impacts. What I mean by that is that the way that we discipline kids, it doesn't fall evenly. So this chart shows some data from just this past year that was compiled by the Washington Office of the Superintendent of Public Instruction, OSPI. And what this shows is just the percentage of each racial group in Washington state, the percentage of those students that will be suspended or expelled. So among all the white students in Washington state, a little over 3% of them will be suspended or expelled in a given year. And that's pretty close to the statewide average, about 3%. If you look, though, at African American students, more than 8.5% of African American students in any given year will be suspended or expelled. Those higher levels are also present for Pacific Islander students, for students who are biracial, for students who are Latino, for students who are American Indian or Native American. All of those students are suspended or expelled at significantly higher rates than white students are and than Asian students are. The same holds true for different populations of students. OSPI also tracks discipline data by whether a student is a migrant, whether they are an English language learner, whether they receive special education services. And again, migrant students are significantly more likely to be disciplined than non-migrant students. If you compare those two bars, migrant students are suspended about 5.5% per year, non-migrant students a little less than 4%. The only place where there's sort of even distribution is between English language learners and non-English language learners. They are both suspended and expelled at slightly higher rates than the they're both suspended and expelled at basically even rates to each other. The biggest disparities statewide exist for students who receive special education services. They are on whole about 8% of students who receive special education services are suspended and expelled versus a little over 3% for students who don't receive those services. Now, those numbers exist, as I said, statewide. So this is kind of a different way to look at that data. What this slide shows is the likelihood that a student will be suspended and expelled given that population within the school district. So this is a concept called disproportionality. And what disproportionality does is it basically looks at the percentage of students in a school district versus the percentage of those students in the population of suspended and expelled kids. So let's imagine for a second you have a district that is 100 children, right? And 50 of those children are boys and 50 of them are girls. If all things are equal, that's a 50-50 split. If all things are equal among students who are suspended and expelled, the population of suspended and expelled students would also be 50-50. And so basically this looks at the likelihood or the comparison between the population of that group in the overall school population and then the population of that group in the percentage of students who are suspended and expelled. Basically anything above 1 means that a group is more likely to be suspended and expelled than you would expect given their percentage in the student population. And again, this is statewide, right? So these numbers kind of even out a little bit based on averages. But again, what we see is that Native American students, African American students, low-income students, students who receive special education services, all of them are more likely to be suspended and expelled than we would expect given our general population numbers. Now, these are, of course, statewide averages, right? And statewide averages don't always tell the whole story of what's going on in a particular school district or even in a particular school. So this I find kind of interesting just because if you look at Washington State, right, there's some pretty big variation. There are some school districts where 1 out of every 4 students can be expected to be suspended or expelled in a given year. And there are some school districts where almost no students are suspended and expelled. Some districts are heavy users of discipline. Some districts are less heavy users of discipline. Incidentally, if you want to see what your individual school or your individual district looks like, the Washington State Office of Superintendent of Public Instruction, OSPI, has published this data for every school district in Washington. So if you just go into any search engine and you look for OSPI discipline data, it'll bring you to an Excel spreadsheet that you can play around in to see what is going on in your particular school or your particular district. But certainly those disproportionalities look different in every jurisdiction. In some schools, African American students are 4 times more likely to be suspended and expelled than you would expect. In some districts, special education students are 7 or 8 or 10 times more likely to be suspended or expelled than you would expect based on their proportion in the population. And as the video pointed out earlier, suspension and expulsion are not just a school phenomenon any longer. Increasingly now, schools have on staff or in the district people called school resource officers or SROs. SROs look a little bit different in every different school district, but as a sort of shorthand, it's cops in schools. They may be cops, police officers who are actually on the school payroll. They may be on the payroll of the local police department, but placed or based or housed in the school. Increasingly, American schools are using school resource officers to handle school security and also now increasingly to handle school discipline. And there has been a lot of research recently that shows that schools with SROs, even if they're compared to other schools that are very similar to them in all other respects, tend to have more arrests for what we call subjective misbehavior, things like disorderly conduct or disrespecting a teacher or acting out, are with the presence of school resource officers much more likely to turn from routine school misbehavior that would land you in a principal's office into criminal cases and criminal charges. If you've been watching the news recently, there was a pretty horrific incident in South Carolina of a high school student who was pretty violently arrested in her classroom for the crime of refusing to put away her cell phone during class and mouthing off. And she's actually facing criminal charges, as is the student who videotaped the incident and stood up afterwards and said, "What do you think you're doing?" to the police officer. She's also facing criminal charges for disrupting school, which is a crime in that particular jurisdiction. What's particularly troubling about all of this is that there isn't really any evidence that this is making schools safer. The vast majority of suspensions and expulsions around the country are for things like insubordination, disrespect, talking back. So not things that are legitimately dangerous to the physical safety of schools. And there's really no evidence that shows that suspending or expelling students for any of these behaviors improves school safety, at least not compared with other forms of dealing with young people's misbehavior. In fact, there is a lot of evidence that school districts that work to decrease their levels of suspensions and expulsions actually have better outcomes. Oakland and Baltimore, which are two of the larger, more high poverty, high violence school districts, frankly, in the country, have recently moved away from exclusionary discipline practices and school resource officers and towards what they call restorative justice, which instead of pushing kids out when they misbehave, the goal in those districts is to keep kids in, to make them accountable to the school community for what has gone wrong, and to encourage them to make amends in whatever way is necessary and helpful for the continued safety of the community. And I'll talk a little bit more later about what some of the positive outcomes have been in those jurisdictions. But really, it seems like there have been amazing results, not just in school safety, but also in academic achievement and school climate, when schools move away from this sort of punishment model to a more restorative, justice-oriented model. The last thing I'll say before I get into how you actually address these issues is that suspension and expulsion are pretty closely correlated with kids doing worse in school and also being more likely to end up in the criminal justice system as adults. And that's not, I think, surprising to anyone who's ever been a teacher or been a parent or been in a classroom, because you know kids aren't in the building, they're probably not going to be learning much.
Worried about who we were playing because we were basically playing pros. But we won one of our matches in 3 sets, and then we lost the other one.
I'm sorry. I'm not sure why we can hear someone else, but it went away.
Okay.
Okay, there you go.
So the other thing that I'll just point out really quickly is that there are a lot of people who believe that the disproportionalities that we have in suspension and expulsion rates in Washington State are related to the disproportionalities we have in graduation rates. Washington's graduation rates, certainly have gotten better over time, but generally they are much lower for students from more marginalized backgrounds than they are for students from more advantaged backgrounds. The disproportionate discipline may play a role in feeding into that disproportionality in graduation rates and achievement. So the next little section here is really going to focus on how folks can help advocate for individual students and also for more systemic changes in these areas. So under our state constitution and our federal constitution, students have a number of rights when they are being disciplined and deprived of their right to an education. So I'm going to go through these rights in some detail, although certainly not as exhaustive as I think, I could, but I'm certainly happy to answer more specific questions if people have them. So the first thing is students have a right to know what they could get in trouble for, right? They have a right to clear notice of what the rules are. The rules have to be spelled out in handbooks and in policies, and the rules have to be clear enough that students can understand them. In addition, if a student is going to be suspended or expelled, the parent has to be notified as soon as possible of the suspension and expulsion. And I'll get to this a little bit later as well, but if a parent is known to the district to not be a native English speaker, they have a right to the notice of discipline in a language the parent can understand. So it has to be translated, or there has to be an interpreter provided to the family. If a student is going to be disciplined or suspended, they have several different rights for an opportunity to be heard, which basically means that they have to be given a chance to tell their side of the story. How much of a chance and how many different kind of appeals you get depends on the type of discipline, whether it's a short-term suspension, a long-term suspension, or an expulsion. So I won't go into that in huge detail, but basically it starts out with an informal conference with the administration. So before the child can be formally kicked out and served the suspension, there has to be some kind of an informal conference with the school administration where the child or their family can present their side of their story, their position on why the child should or shouldn't be disciplined. If that meeting does not go well, the family can also file for what's called a grievance conference with the principal, asking the principal for a formal meeting to, again, go over the incident and the reasons. From there, you can go to a meeting with the superintendent or a formal hearing before an administrative review judge. And then from there, an appeal to the school board or even to the Superior Court. The process for going through these grievance processes, there are very strict timeframes on them. They are often very, very short, like 3 days, 10 days. And if a family doesn't request their hearings within that time period, they essentially can be held to have waived their rights there. So it's really important when a child is disciplined for families to engage in the process as soon as possible to ensure that they get all of the levels of review that the law, gives to them. In addition to that, substantively, the punishment has to fit the behavior. And so there are a few limitations on that. The first is that, students can't be subject to exclusionary discipline for a first offense, so the first time they engage in this behavior, unless what they do is quote unquote exceptional misconduct. Exceptional misconduct is one of those words that school districts define on their own. So what counts as exceptional misconduct, the school district has to set it out in their rules or policies so that people can understand it. In addition to that, particularly for younger students, there are some hard and fast protections. So students in kindergarten through the 4th grade cannot be long-term suspended or expelled. It is not allowed under state law. They can be short-term suspended, but only for up to 10 days per term. Some districts may have more protective policies. So for example, Seattle just this year voted on what they call a moratorium. So basically a timeout on suspending elementary school children for nonviolent behavior. So that in Seattle is no longer going to be happening under our policies, and other districts may have more protective policies in place as well. And then the other limitation on the punishment having to fit the behavior is that for students in the 5th grade and up, they can only be suspended for 15 days in any given semester or 10 days in a trimester. So again, the goal is to keep those suspensions from functionally, requiring kids to fail a grade and give them the opportunity to come back and make up work. In addition to that, there are some new rules that went into effect in 2013, new laws, that are designed to try to ensure that kids who are suspended and expelled have the opportunity to get back into school. And these are, again, they're fairly new laws. But what they require is this. So the first thing is suspension and expulsion have to be limited. They have to be limited to 1 year. And cannot be indefinite forever. Students are also entitled to a re-engagement meeting with the school. What that means is that if a student has been suspended or expelled, the school has to then develop a plan with the family to get that kid back into school. The re-engagement meetings have to happen at least 5 days before the end of the exclusion. So if a kid is long-term suspended for 20 days, they have to have their re-engagement meeting at no later than day 15. Or it has to happen within 20 days of the suspension and expulsion if that suspension and expulsion is for longer than 25 days. Re-engagement meetings are really supposed to be designed to help come up with a plan for moving forward. So it's not an opportunity to rehash whether or not the student should have been disciplined. It's really designed to ensure that there's a plan in place for the school district and for the family to make sure that the schools can, that the kid can come back in, can resume their education. Even when a student is suspended or expelled, they should always be pushing for alternative education services. So even if a child can't be in the physical school building where they are, students and families should constantly push for the school to provide kids with something, whether that is alternative schools, whether it is online learning, whether it is home tutoring. Kids in Washington have a fundamental right to an education, and if a child is going to be excluded from the school building, they and their family and their advocates should be pushing for them to receive educational services no matter where they are. And finally, even if kids have been suspended and expelled, they always have the option to petition the school to readmit them, to let them back in. Readmission meetings can get a little complicated, but the gist of it is that kids should be prepared and their families and advocates should be prepared to explain why they're ready to go back to school and how they're prepared to address whatever incident or behavior led to them being excluded from school in the first place.
Vanessa, we do have a question over here. I think it's referring to your previous slide. What is notice? Does it mean calling the parent? What if the parent doesn't have a phone? Like, does the school send a letter? What if the parent doesn't respond? So it seems like there are no rules about how long the wait is before the school moves forward. So can you address that?
Yeah, so in terms of the notice, there aren't strict rules on exactly what form the notice has to take. It has to be given as soon as possible, and it has to be given in a language that the parent has access to. It can be either a phone call or a letter. And if parents don't respond, the school districts do just move ahead. And unfortunately, what happens then is that if parents don't or families don't respond within the required notice timeframes, the school district can move ahead with its discipline and there's no rights to appeal or review. Again, the waiting period issue depends on what type of discipline the student has been subjected to. The Office of Education Ombuds, and I'll direct you to some of their resources later, has some really good flowchart kind of guides about, for particular kinds of discipline, what are the waiting periods for those particular things. But that was a great question. I encourage more of those kinds. Okay, so moving ahead to how advocates can assist here. On an individual level, there is, I think, a really big role for advocates to play in terms of helping parents, families, and students navigate these processes, right? These time frames can often be complicated, and making sure that families understand, that they should get notice, what should be in the notice, that they have rights to respond to that, is always incredibly, incredibly helpful. It's also really helpful during disciplinary hearings or conversations for children and families to be able to present examples of community supports, right? Or context for the behavior. So if, for example, a child is going through a particular traumatic experience, it can be incredibly helpful sometimes for advocates to support children in explaining, that they're going through a traumatic experience and that their behavior, while maybe problematic, is more related to trauma than it is a deliberate choice to misbehave and disrupt the school system. And ensuring that school districts understand that children have supports, that they have other ways to deal with whatever issues led to the misbehavior, can often help support either the removal of a disciplinary sanction or can encourage school districts to help get kids readmitted more quickly or more fully than they otherwise would. Similarly, helping people to gather information related to the student and what's going on in their lives or in their community can again be really helpful. Sometimes school districts will have misconceptions about students, believe that they lack community supports, and again, that kind of community support and involvement is often a really big factor in whether kids are getting either pushed out of school altogether or readmitted. And I think, again, advocating for a sort of trauma-informed, student-centered approach to changing behavior, focusing again on all the goals, right? Everybody's goal in this process is to ensure that children's behavior change and that they are not disruptive to the school process. Providing school districts with other options, other ways to deal with behavior other than I'm just going to kick this kid out because I don't want to deal with them can be incredibly, incredibly helpful. The school discipline process is not limited to lawyers. So it's not like going into criminal court where people must be represented by a lawyer in almost all circumstances and can't be represented by a non-lawyer advocate. In school disciplinary processes, people have the right to a lawyer. They can bring their own lawyers if they like, but even if a family doesn't have a lawyer, they can have advocates or other individuals working with them in this process. Team Child, and there's a website link down there, has a really wonderful guide towards advocacy, educational advocacy that is geared towards families that can help people, advocate for students and other folks they work with during the disciplinary process. And the ACLU also has some of these materials, which I'll cite to you at the end of this presentation.
I'm just going to pause for a second over here, Vanessa. I need my little screen. So let's try this one more time. Sorry guys, give us a second over here. Okay. There we go.
Okay. The other thing, though, that I will note is that individual student advocacy is kind of only the tip of the iceberg in this arena. School discipline is one of those areas where families and advocates and students have been incredibly successful in building coalitions to advocate for systemic change. So beyond just advocating to change the discipline or suspension of one student, really pushing to change policies and practices and cultures district-wide. A really fabulous example of this is an organization in Colorado that started out in Denver called Padres y Jóvenes Unidos. that was an organization that started back in 1992, really in response to just one elementary school administrator who was using pretty horrific discipline practices and directed almost entirely at immigrant children. And so families got together, and once they realized that, you know, this was happening not just to one child, but to many, many children, and they organized and pushed for that particular administrator to be removed and additional training to be done for their staff, which they accomplished, right, on an individual school level. But they realized very quickly after they started getting phone calls from parents and advocates and family members all around the state that there was a need for sort of a broader organizing movement. And so over the past, 20 years, this organization has really become the leader in a push for systemic school discipline reform in Colorado. And in 2012, they led what was called the Smart School Discipline Coalition that actually got a new school discipline law passed for the entire state. And what that discipline law did was really enact a lot of the model policies here, right? Having consequences be graduated, so starting out with smaller consequences and reserving the biggest consequences for the most serious or most problematic behaviors. And requiring school districts to engage in prevention strategies, restorative justice, peer mediation, counseling, all the things that are designed to figure out why are kids acting, you know, in ways that are problematic in schools, and how can we change or support that behavior, or, you know, require the child to make amends in a way that keeps them in the school system as opposed to pushing them out. It also required intensive training for school resource officers, so they were acting more like a part of the school community and less like law enforcement agents trying to, you know, make arrests. And as a result of that, out-of-school suspensions and expulsions and referrals to law enforcement in Colorado went way down. And they're continuing to see improvements in practices and policies there. So I offer that as an example to show how valuable it can be when advocacy groups and families band together to try to change not just what's happening with one student, but really the way that districts are operating on a more systemic level. There are tons of models out there in Washington and nationally for how we can deal with kids' behavior in ways that keeps them in school. And I've just given you kind of a few lists of examples. Some of the ones that I'm most excited about are restorative justice programming in schools. And I mentioned that Oakland and Baltimore have both adopted that in some of their schools. And basically what they are doing is they're saying if a child engages in misbehavior in school, they are equipping teachers with the resources to get those kids together with the entire school community and focus on what are the causes of the misbehavior, what can be done to address that, how can the person who acted out make amends to their school community and make amends to whatever victims there were of the offenses and make things right going forward. Oakland, since it adopted its policy, has actually, tested it by looking at outcomes in schools that have restorative justice programs and schools that don't. And what they've seen has been really amazing. Not only have the restorative justice schools dramatically reduced suspensions and expulsions, but they've had broad-based school outcome improvements. Reading levels are up, graduation levels are up, absenteeism is down, dropout rates are down. In Baltimore, there's even some evidence that crime rates in the neighborhoods around the schools are down because kids are in school learning productive behaviors as opposed to being pushed out. And again, all of these organizations have many, many more resources about how to implement these sorts of programs in schools and beyond. So with that, I'll pause. If anyone has additional questions about the discipline issues, I'm happy to answer them.
Okay, we don't have any questions right now. Give it a second in case someone's typing. Okay, it looks like we can move on. And if something comes up, then I'll see where we can pause.
Okay.
Oh, this is awesome info. Well, thank you. It's, I must say, Vanessa, while we're pausing and, just in case people are still typing, it's just so great to like hear the district and the statewide data and like how it's disproportionately impacting students of color and immigrant students, and like also there's also a lot of hope in terms of what schools and parents and how communities are really stepping up to address this issue. So it's not like it's a hidden issue. And I love that Washington State is protective of our students, and we're just like looking at how can we make the system better. So that's really great.
Yeah, and this is one of those areas that sometimes is really fun to work in, because I think at the end of the day, almost everybody who is involved in these systems wants the same things, right? We all want kids to do well. We all want kids to be in school. We all want kids to succeed. And really the questions and conversations we're having are, where can we have improvements and what can we do better? And that's a really positive place to be able to work.
Awesome.
So with that, then, I will turn to the second issue here, which is pregnant and parenting teens. Again, like school discipline, pregnant and parenting students can be found in all portions of the population, but are disproportionately represented among students of color and immigrant students. So pregnancy and parenting is a lead reason why students, particularly girls, although there are also some boys, are dropping out of school. So by some estimates, basically 50% of kids who are pregnant drop out. They leave school voluntarily, they're pushed out of school, and oftentimes they never return. Teen pregnancy is disproportionately concentrated among African American, Native American, and particularly Latino students in Washington State. So this little pie chart sort of shows you what the percentages are for teen birth rates. So this is young women under 20 giving birth. This portion here is white students who account for about 50% of teen births. Latino women account for about 35%. Asian Pacific Islander account for 5%, African Americans for 6%, and Native Americans for 6%. Now, that is disproportionate. This is not what the pie chart of Washington's general population looks like. Latinos in Washington are only 12% of the overwide state population, but they form 35% of the teenagers who give birth. Similarly, Native Americans are about 2% of Washington populations, but are about 6% of the teenagers who give birth. So again, these are disproportionately concentrated in communities of color. Now, this is a civil rights issue, right? It's one thing if people, if young women become pregnant and then choose on their own volition to leave school, right? That parenting is hard, right? Being a teenager is hard. Some people just decide they're not ready for school, but that's not really what's happening, because the vast majority of young women, and again, it's mostly women who are dropping out because of pregnancy or parenting, are not dropping out because they want to. Instead, 70% of them say the reason that they are dropping out is school-based obstacles, meaning the school is making it too hard for them to do what they want to do by staying in school, even though they are pregnant and parenting. Some examples of what we've seen and heard about both nationwide and locally. Sometimes school districts just tell kids, well, you can't stay here. We don't want you here anymore. This isn't the right place for you now that you're pregnant. Sometimes they exclude students from classes or activities. Students are told, well, you can stay in school, but we're not going to let you stay in PE because you can't be in PE when you're pregnant, and so you're not going to graduate. So sorry. Or students are excluded from clubs or activities There are a whole ton of cases all across the country of young women being excluded from honor societies, even though they otherwise would qualify because they are pregnant, and thus they are a quote-unquote bad example. Some school districts automatically send kids to alternative programs. They said, fine, you can stay in school, but you can't stay in your school. You've got to go to the alternative school down the road. They refuse to give makeup work or excused absences for children who miss school because of pregnancy or parenting or caring for their children. And sometimes it's just discouraging or disparaging them. You know, our office talked to a young woman who, when she got pregnant, her favorite teacher brought her into school and said, well, now you've ruined your life. And what are you going to accomplish now? Now you're going to accomplish nothing, right? And when your favorite teacher is telling you you're done, you know, most kids in that situation would say, okay, fine, I'm done. I'm not going to be here anymore. The law here, though, is actually really abundantly, wonderfully, incredibly clear that all of that is illegal. Okay, the law in Washington, both our federal constitution, our state constitution, and federal and state laws say that people cannot be discriminated on based on sex. And then that pregnancy discrimination is discrimination based on sex. So it is illegal in Washington. It is illegal everywhere under Title IX of the Education Amendments of 1972. That's the federal law up here at the top. And I'll talk about Title IX a lot here as shorthand because the requirements under state and federal law are pretty much the same. The rights that pregnant and parenting students have are, as I said, very clear, very protective. And they've all been reduced by the ACLU into a little tiny fold-up wallet card that I've reproduced here. You can download the wallet card at this website down here, or if you want actual physical paper copies so you can hand them out to all the young people in your life who may be facing these issues, get in touch with me and we can make sure you get copies. We have them available in both English and Spanish. So I'll go through these bit by bit and try to give some examples. So the first is pregnant and parenting students have the right to stay in their school, which means they cannot be kicked out, they cannot be told to leave, they cannot be told they have to take time off of school, and they can't be forced to go to an alternative school or a separate program. Many schools offer alternative programs, and too often we hear, well, all the pregnant kids go to the alternative program. Children can be offered the option to go to an alternative program, but it must also be clear to them that they have the right to stay in the school that they were enrolled in before they got pregnant and parenting. Pregnancy is not itself enough of a reason to send a kid to an alternative program. Kids who are pregnant and parenting also have the right to be safe and welcome. That means that they cannot be harassed, they cannot be bullied, certainly not by the teachers, but even by students. So if children are being regularly harassed by their peers because of their pregnancy or parenting, the school district, if they know about that, has an obligation to address that, to remedy that situation. So if children are being bullied or harassed because of their status as pregnant or parenting, it should be reported immediately to a trusted adult. Kids have the right to participate in all school activities and clubs just like any other student. So pregnant and parenting kids cannot be denied access to the debate team or to the track team or to the honor society just because they are pregnant and parenting. School districts are required to make some accommodations for kids. So if, for example, a member of the track team isn't kicked off just because they sprained their ankle, the pregnant member of the track team cannot be kicked off simply because she is pregnant. Pregnant students have to be treated just like any other student who has a temporary disability, and that means full levels of access and accommodations that are medically necessary. Pregnant and parenting students have the right to excused absences. So any pregnancy-related health condition or doctor's appointment for the pregnant student or their child must be excused. The absences have to be for as long as is medically necessary. So the doctor gets to decide how long a child needs or how long a parent needs in order to get healthy again, and the school district has to accept that medical judgment. And they also can't require additional paperwork to excuse absences for pregnant or parenting teens. So sometimes we'll hear that pregnant or parenting teens are told, well, you need to get a signed doctor's note and a signed parent's note every time you have to miss school for pregnancy or parenting. The school district can only require all of that if it also requires that for kids who have other medical conditions. In addition, pregnant and parenting students have the right to make up any missed schoolwork, and they need to be given a reasonable time to make up their missed work. The work doesn't have to be identical, but it has to be reasonably equivalent and allow the student to catch up academically. They may also be entitled to additional help. If, for example, a kid who has a non-pregnancy related medical condition gets home tutoring or home instruction, then pregnant and parenting students also have to be given home tutoring and home instruction. And finally, pregnant and parenting students have the right to stay in all of their classes. So they cannot be discouraged from taking or finishing a class. They can't be told, well, calculus is going to be really hard for somebody in your condition, so maybe you should take something else. Where this comes up a lot is in PE. For some reason, people seem to think that pregnant women can't do PE class. And the answer is that school districts can't assume that pregnant students can't participate in PE. They can't require medical permission for students to participate in PE. If a student can't fully participate due to pregnancy in all of the activities that are required for PE, the school district has to provide reasonable alternatives, just the same way they would for a kid who broke his or her leg, right? Pregnancy can't be treated differently than any other temporary medical condition. So the law here is really, really good, right? And where advocates can help primarily is in helping to ensure that students and frankly school districts are aware of the full range of options and obligations here. Again, often, pregnancy and parenting is hard for adults, and it's especially hard for kids. And oftentimes, discouragement or limitations by adults can weigh really heavily on kids at this time in their lives. So being an encouraging voice and helping kids to understand their full range of options, that they have the right to accommodations, that they have the right to supports, that they are entitled to be in school and to be supported in that, can be really valuable and empowering for kids. In addition, I think, again, oftentimes school districts are maybe not necessarily acting maliciously here, right? They're not plotting in a back room with evil laughs saying, we are going to kick out all the pregnant kids. But oftentimes they just don't know what else to do. So if you are an advocate who works with a significant population of school-aged kids who are pregnant or parenting, even just connecting with the school districts and saying, hey, I'm an advocate in this area, I know what resources are available, feel free to call me if you need information or additional resources in the community that I can connect you with. And then helping students to lodge complaints when it is necessary. And I don't mean, filing lawsuits necessarily. Every school district is required to have a Title IX coordinator. So under Title IX, they are required by law to have one designated person who is in charge of enforcing Title IX obligations, including the laws around pregnant and parenting teens. So that's where students should go if they have concerns about the way that things are being handled in their school, the Title IX coordinator is kind of the first point of contact, helping students to identify who that person is, helping students to present to that person can be really empowering in terms of ensuring that student rights are being respected fully in this area. So any questions related to the pregnancy and parenting issues or other things previously?
So let me just expand this over here. So we do have one clarification question. It's from the previous section, and the clarification is this advocate is saying that she thinks that minors were not to be interrogated by police unless the parents are present. So I think that's in reference to the school resource officers.
Yes. So as a general rule, minors can't be interrogated by police without parents being notified and being present if they can be. But school resource officers are, sometimes still a bit of a gray area under the law. Generally, school resource officers shouldn't be questioning students related to an arrest. But what school resource officers do when they're not arresting, I think still gets a little complicated. The other part of the problem is oftentimes the questioning is not done by the school resource officer, it's being done by a school administrator or a teacher with the school resource officer in the room. And the law in this area is still developing. My read of the laws in Washington is that school resource officers should never be questioning students without giving them their full constitutional protections, whether the questioning is happening in school, out of school, related to something that is being classified as just discipline or not discipline. Given what school resource officers do, given their duties, I think that every interaction they have with students should be protected just the same way those interactions would be protected, if they weren't happening in school. But the law is still evolving in this area, in part because there's so many different ways that school resource officers operate all around the country.
Awesome.
Any other questions about the pregnancy and parenting issues or school discipline issues?
So one question just came in. How can the school districts prepare their teachers to avoid discriminating pregnant students? Teachers should be obligated to know and clearly understand their district policies.
Yes, I absolutely agree. And there's two recommendations I would offer to advocates. The first is you should go and check your school district policies to see if they even have a policy on pregnant and parenting teens. There are model policies that have been developed by the Washington School Directors Association, and there's also pretty detailed guidance from our state Office of Superintendent of Public Instruction. But not all school districts have adopted these policies formally. So the first question is, does your district have a policy? And if they don't, they should be encouraged to adopt one based on the models that are already out there in the state. But yes, school districts and teachers absolutely should be given training on these issues. OSPI offers it, we offer it. There are a number of organizations that are willing to do training and information for teachers on these issues.
Awesome, thank you. The next question is, in regards to a pregnant teen, what does the law say about a teen having postpartum time away from school? Does anything support them to have time off and prevent them from getting behind on coursework and credits?
That's a great question. And the answer is yes, the law requires teens to have postpartum time off. They are entitled to as much time off as their doctor deems medically necessary based on the particular birth situation they had or the needs of their child. And if a student is missing days of school with excused absences because of birth or because of necessary childcare, they are entitled to make up work that will allow them to achieve the credits that they need to earn. The work, again, doesn't have to be identical to what they got. So if, for example, there's a test that that other students took that only could be given once for whatever reason, they don't have to take that identical test, but the school has to provide them with something equivalent that allows them to get those credits.
Awesome. I think we are ready to move on.
Okay, I see one last question there.
It's about sending us links and model policy. So I think we'll just have to work on getting that out.
Yes, and I can certainly get you links to the model policies and the regulations on pregnant and parenting teens from the Washington State School Directors Association and the Office of Superintendent of Public Instruction. Okay, great. So then the next section is going to deal with homelessness, homeless students. Again, an issue that does not only impact immigrant or migrant students, but that disproportionately impacts them. So about 30,000 students in Washington have been identified by school districts as meeting the legal definition of homelessness. And you'll notice there's a little asterisk up there because there is really good evidence that that number is not all of the kids who are out there who would meet the definition. Our state schools have identified about 27,000 students as qualifying for services because of homelessness, but in an audit done by the Department of Social and Health Services, they estimated that there are about 42,000 students who would qualify as homeless. So, we know already that even though districts are supposed to be identifying homeless students, there are a lot of kids out there who qualify as homeless, who would qualify for additional services, but who for whatever reason aren't being identified by their districts and provided with those additional services. So what makes a child homeless for the purposes of federal law is this definition. They is a person who lacks a fixed, regular, and adequate nighttime residence. So in order for a child to qualify as homeless, their residence can be either not fixed, not regular, or not adequate. If any of those three things are missing, the child would qualify under what's called the McKinney-Vento Homeless Education Act. And so I'll refer to McKinney-Vento. That's the law here that defines homelessness and also the obligations that schools have. So a couple of quick examples to help you understand. The definition of homelessness here, I think, is broader than many people think of in the traditional sense of popular culture homelessness. So in order, a child who lacks a fixed residence is considered homeless. So a fixed residence is one that is attached to the ground. So cars do not count. Children who are living in their cars or in camper vans are considered under McKinney-Vento to be homeless. Tents also do not count as a fixed residence. The residence has to be regular. And what that means is that the kid has the legal right to be there every single day. So couch surfing does not count as a regular residence. Living temporarily with relatives because you lost the lease on your apartment doesn't count. Crashing with friends doesn't count. Transitional shelters or homeless shelters do not count as regular residences for the purposes of McKinney-Vento. Children who are awaiting foster care placement, so who haven't been placed in a long-term foster residence, also are considered to be homeless and lacking a regular residence. And finally, the residence has to be adequate, which means that it is fit for human habitation. So people who are sleeping in abandoned buildings or warehouses, people who are sleeping in their home, in a business, right, that's not intended for humans to live in, that's not considered adequate. So there has to be heat, there have to be lights, there has to be water. It has to be a place intended for people to live in, not just a space where people are living out of necessity because they have to. So homelessness and student homelessness in Washington is a really really widespread problem. And again, I think beyond what we traditionally imagine for homelessness. So it affects kids of every grade level, right? 49% of homeless students are in 5th grade or below. So this impacts even the youngest children. it impacts just about every county in Washington. So in 93% of Washington counties, more than 2% of the students currently attending schools are homeless. What that means is that there are very, very few parts of Washington state with a tiny population of homeless students. In most parts of Washington state, there is a significant concentration of students who are homeless. And then important to remember, about a third of homeless students are attending schools in rural areas. I think we traditionally think of homelessness as an urban problem, as, you know, people literally sleeping on the streets under freeway overpasses, but increasingly homelessness is also a rural problem. And it's not confined simply to cities. So again, it is widespread. It impacts all parts of Washington state, rural, urban, and everything in between, and it impacts students at all grade levels. Now, again, not surprisingly, homeless students often have a really difficult time maintaining stable school attendance. This is a survey that folks have done of what is keeping homeless kids out of school, and you'll notice the percentages add up to more than 100 because many families identify more than one reason. You know, a big driver, honestly, is that when families are homeless, they are worried about their basic survival needs, and sometimes school attendance or regular school attendance is hard to do when families are worried about keeping a roof over their heads, keeping safe in the night, and, you know, meeting basic food and medical needs. But the other big ones are really school-based or government-driven obstacles, right? One of the biggest ones is a lack of transportation. Kids just not having a way to get to school, or an inability to do homework, or a lack of a safe space to do homework in, a lack of clothing and supplies, or poor medical care or health care. You know, part of what makes this particularly problematic is that homelessness not only disrupts families' lives more generally, but it also has really tremendous educational effects. So national studies have shown that about 42% of homeless students transfer schools really for no reason other than the fact that they are homeless and have to move around a lot. What's really scary is that every time a kid changes schools, that functionally results in the loss of about 3 to 6 months of education. So every time a student has to leave their school because of homelessness, they end up being, you know, 6 months behind, half a year behind. And because of that, not surprisingly, homeless students have really significantly lower educational outcomes than kids with stable housing. So the McKinney-Vento Homeless Education Act is designed to try to address all of those issues by creating some really specific protections and obligations for homeless students. And I'm going to kind of run through these bit by bit. So the first is that homeless students are entitled to a free and appropriate education. Free meaning they cannot be assessed any funds, they cannot be denied participation in activities because they lack funds, and their education has to be appropriate to their particular needs, which means that schools, you know, to the extent that they are providing supports, should also provide supports directly targeted to meet the needs of homeless students. Homeless students are entitled to comparable services to those that non-homeless students receive. So they are entitled to receive free and reduced lunch, and they cannot be required, if a student is identified as homeless, they do not have to submit all of the necessary paperwork in order to get free meals at school. They must be provided those meals even if they don't have all of the paperwork that would otherwise be required. Homeless students must be evaluated for special education services and again provided with the full range of special ed services. They must be enrolled immediately in school. And again, school districts often require lots of paperwork, right? Where's your immunization records? Where do you have a water bill to prove that you live in this district? But students who are identified as homeless cannot be required to submit that paperwork as a condition of enrollment. They have to be enrolled, and then the school district has to work with them to get whatever paperwork is necessary. In addition to that, homeless students are entitled to attend either their local school or their school of origin, and I'll define those terms for you. The local school means the school in the district where the student is currently residing, where they are sleeping in the shelter, where they are crashing with relatives, where they are sleeping in their car, whatever it is. The closest school to where they are currently living. Or homeless students can choose to remain in the school of origin, which is the last school district they were enrolled in, or the last school they were enrolled in before they became homeless. So if a child is enrolled in a particular school and then has to leave because their family lost their lease on their apartment, the student is entitled to stay in that school if they want to. And if they want to stay in the school of origin, the school district is required to provide transportation to the school of origin. So homeless students are entitled to transportation either to their local school or to the school that they used to attend and want to continue attending. School districts must have a homeless liaison who is designated, who is the person who helps homeless students navigate the enrollment process and also can provide information and supports to the homeless family on programming, referrals to healthcare services, referrals to other social services. And then school districts have to provide notice of these rights to students and also track how homeless students are performing and ensure that these obligations are being met. Now again, homelessness is one of those issues that disproportionately impacts immigrant families and migrant families, and also disproportionately impacts poor families. So having folks be aware of these rights can often ensure that they're getting the sorts of services and supports they need. So how advocates can help in this area. Connecting families and students with the appropriate resources, especially the McKinney-Vento liaison at every individual school or school district, can be incredibly helpful to ensure that families know that they can get enrolled and go through the process without being overwhelmed by paperwork requirements that don't apply to them. The Office of Superintendent of Public Instruction maintains a list of McKinney-Vento liaisons for every school district in Washington, so you can go there and look up who is in charge in that district of coordinating McKinney-Vento services. Encouraging partnerships with school districts as well can be really helpful. And these partnerships can both help school districts identify homeless students, right, by ensuring that people who are dealing with homeless young people know who to connect with at the school, but also to ensure that districts know what kind of resources they can refer people to if they need, clothing or healthcare assistance. And then providing information about the benefits of identifying as homeless to students and families. There is still a pretty large stigma around homelessness. And some people have guessed that one of the reasons that school districts haven't identified every student who would qualify for services here is because families and students are reluctant to self-identify, to kind of go up and say, yes, I am homeless, give me all of these things. And providing information to students and families about the benefits of that identification and the supports that students become eligible for oftentimes can help to, if not remove the stigma, at least encourage folks to recognize that there is a benefit and it's not all just stigma. Any questions or comments about the homelessness issues?
So there are a couple of questions that have come through. The first question is if you can identify for us again how do you identify a student that's homeless?
Yeah. So the basic definition again is a person who lacks either a fixed residence, a regular residence, or an adequate residence. It's really hard to come up with every single example, but OSPI and also the gosh, and now I'm blanking on the name, but OSPI and I think it's the National Coalition to End Homelessness have both published guides with lists of questions that advocates and teachers can ask to help them identify students who are homeless. So if you look for those kinds of resources, that can help you identify, is a child living in a shelter? Are they awaiting foster care? Are they living in their car? Are they crashing with relatives or friends? Do they live in a place that's not, designed to be a home? Those lists of questions can help people kind of hone in on those particular factors, which again will vary a little bit kid by kid.
Okay, great. And then the second question is there a limit in transportation to the school of origin?
That is an excellent question, and I don't know the answer to that off the top of my head. I don't believe there is, but I'd want to check that, and I can certainly get back to you on that.
Okay, great. So let me just expand this. Okay, great. The next question is, with schools using online resources for homework more and more, are there alternative homework schools must provide for students who don't have access to internet on a regular basis?
That's a really great question and something I haven't come across directly. I would argue that McKinney-Vento requires schools to accommodate the needs of homeless students and provide them with comparable services. So if a student is, lacks access to the internet on a regular basis because they are homeless, I do think then the school district has to come up with a way to ensure that student can do their homework and get the credit and services they need in order to complete school. And whether that's non-internet based homework or whether it is a place in the school building that the student can come in order to do their homework at school, I think that's certainly something that you can push for and advocate for.
Okay, great. And then the final question is one loophole that this person has found is with McKinney-Vento is that if there are multiple siblings, they eventually won't be in the same school track as in the school of origin. Like the school of origin is that one school. So if you went to the same school K through 4th grade, McKinney-Vento would only count for 5th grade, and then for middle school you'd have to change. You lose your friends, you can't go to the same school your siblings go to, so I actually don't understand this question, so if you can help clarify that would be great.
I think what this questioner is pointing out is that school of origin isn't necessarily the same as district of origin or track of origin. So students are entitled under McKinney-Vento to attend the same school that they were attending prior to their homelessness, but they aren't necessarily entitled to attend the middle school that they would have attended had they not become homeless. And I do think that that is an unfortunate loophole in the law. And I think that there is a lot of room for advocacy here at the state level in terms of addressing that. And I'd encourage you to get in touch with Columbia Legal Services, which does a lot of advocacy and support for homeless students and is really leading the charge on trying to improve our state laws to further support homeless students. So I'd encourage you to get in touch with them to see what kind of work they're doing on this issue and if they have any plans in the works to try to improve our laws here.
Okay, great. Okay, so there's another question. Many homeless students can participate in some boys and girls clubs after school program, which includes meals as well. Advocates should help families contact them. Some district school buses go directly from the school to the club, but transportation from the clubs
Could be.
could be an issue.
Yeah, and that's a great resource. You're right that Boys and Girls Clubs after school programs often do provide meals and transportation, so that can be another place for students to go if they need, you know, a safe place and some supportive services.
Okay, great. And I think that's all we have as far as the questions go. Let me just get you back to, there
Perfect.
you go.
Okay, so then the last issue are things that we'll cover that are very specific to immigrant and migrant students. And I'm going to talk really about two issues here separately. The first is access to education without regard to immigration status. And then the second issue is going to be English language learner issues and family language access. So it is completely clear and has been completely clear for over 30 years that children have a right to attend school regardless of their race, ethnicity, national origin, gender, sexual orientation, or immigration status. Kids cannot be required to prove that they are documented U.S. citizens or have documented immigration status in order to enroll in school. This was established by the U.S. Supreme Court in a case called Plyler versus Doe in 1982. In that case, the state of Texas adopted a rule that refused to provide state funding to children who they identified as illegal immigrants, and allowed schools to turn kids away unless they could prove that they had lawful immigration status. The U.S. Supreme Court said, nope, you cannot do that. You cannot require kids to prove their citizenship in order to attend school, and you cannot take any actions to deter immigrant kids from accessing school. So what does that mean on a day-to-day basis? Our State Office of Superintendent of Public Instruction has published this handy little do's and don'ts on immigration status. I will say, unfortunately, that there is still evidence that all of these don'ts are happening around the country, even though the law has been clear on this for over 30 years. So, students who are migrants or immigrants must be enrolled in school in a timely manner. The school cannot require them to provide proof of citizenship or documentation of immigration status without before they can enroll. Schools cannot ask people for social security numbers. If they are going to assign student numbers, they have to be generated by the school and cannot be required to be based on a school social security number. Immigrant and migrant students are entitled to the same services as all other kids. They cannot be segregated out into separate programs. They have to be enrolled in the regular school program, and school districts cannot report people's immigration status or parents' immigration status to immigration authorities or police, okay? School districts are not in the business of enforcing immigration laws, and FERPA, the Family Educational Privacy Laws, prohibit school districts from generally sharing information about students and families without their consent. So bottom line is school districts shouldn't be asking about immigration status or requiring information about immigration status. And if for some reason they find out about it, they should not be reporting it to any authorities. School districts are, can require people to provide proof of residence, right? A phone bill or a water bill or something to show that they live in the particular school district. But they have to apply those criteria evenly. They cannot require different students to present different kinds of information. And, to the extent that immigrant students would qualify as homeless, they are entitled under McKinney-Vento to enroll without providing any of that paperwork. Now, on the English language learner issues, this is an area where the law is, a little more evolving and a little more complicated. So in Washington, Washington has about 10% of its students are English language learners. The vast majority of those kids receive what is traditionally ESL, or English as a Second Language type of instruction. Only about 14% of those students are receiving any form of bilingual instruction, which means they're not getting instruction in their home or native languages. Some people think because of that, students who are English language learners tend to perform lower on standardized test assessments pretty much across the board. Again, in Washington, 10% is kind of the statewide mashed out average, but there is pretty wide variety in terms of the percentage of English language learners enrolled. In some districts, more than 50% of the students who are enrolled are English language learners. In other districts, it's close to zero. And so this map kind of shows you where the hot spots are in terms of concentrations of students who are English language learners. Washington State is, in the top 10 in the country in terms of the percentage of our population who are English language learners and children of immigrants. We're ahead even of Arizona based on the data, and Washington State's numbers are continuing to grow. So this is really going to be a big issue for Washington going forward. So English language learner students are entitled to meaningfully participate in school. What that means is that school districts actually have to take affirmative steps. They have to create programs to help kids who are English language learners fully integrate into the school program. They have to act to overcome language barriers formally under the Equal Educational Opportunities Act of 1974. So it's not enough for school districts to just, say, okay, I'm going to throw you in the deep end, kid, and you figure it out. Districts actually have to take steps to help kids learn English to the extent that is necessary to participate in educational programs. Under both federal and state guidance, English language learners have the right to participate in what's called a language assistance program. There are roughly 3 forms that can take. Sometimes it is traditional English as a second language instruction. It can also be transitional bilingual programming, which is basically where a child is taught in both English and their first language, and the sort of proportion of English is ramped up as the child becomes more proficient in English. The other model that's acceptable here is dual immersion, which is basically when students who are native speakers of English and students who are native speakers of another language are put into a classroom where they are both taught in both languages, with the goal of both groups of students attaining proficiency in the other language. Whatever the program is, though, it has to be educationally sound, so it has to be based on research that it is effective. It has to be designed to ensure that kids attain English proficiency and equal participation in the standard instructional program. It has to be led by a qualified teacher, so it cannot be led by an aide or a tutor or some guy down the street. It has to be someone with educational qualifications, and it also has to be in the core curriculum. So that means that English language students cannot be wholly segregated from other students. They have to be able to participate in the full instructional program. In addition to that, families and parents have the right to participate in their school district's programming. So what that means is that vital communications have to be provided to limited English proficient parents in a language that they can understand. So what counts as a vital communication is one of the more complicated things. But for example, parent-teacher conferences. If parents cannot speak English, they have to be provided with an interpreter or a translator to help them engage in parent-teacher conferences. Special education meetings, program information applications, consent forms, complaint forms, notices of rights, anything that a parent is going to have to respond to, or anything that substantively impacts a parent's rights or a child's rights, they have to be given to parents in a language they can understand. And school districts have to develop some process. The law doesn't say exactly what process, but some process to determine the language needs of parents. So for example, in Seattle Public Schools, where my children attend, parents are asked whether they speak languages other than English at home and if they would like communications in a language other than English, and to specify what it is. An additional requirement applies for students who are English language learners and who also have disabilities. Students who have disabilities are entitled to an individualized education plan that's designed to meet their needs. If students are dual services, meaning they have a disability and they are English language learners, their IEP team must also include someone with knowledge of English language instruction. It can't just be teachers or administrators with only special education information. So how advocates can help here. Helping families just understand what these laws and policies are. I think oftentimes when immigration status is at issue, people are rightly concerned and worried and not wanting to engage in these processes. But helping families to understand what their rights are and why districts may be asking information about language can help parents to be more able to fully engage in the process. Providing a bridge between families and districts, helping districts to identify what are vital communications, ways to get that out to families, helping to connect to bilingual or dual language services that may be out in the community. And then I think, again, systemic advocacy here can be really helpful. There have been a number of school districts around the country that have made really positive change in terms of the ways that they are interacting with migrant and immigrant and English language learners, in part because of community supports and community pressures. And then the other thing I'll say is there's a really detailed toolkit here that the U.S. Department of Justice and Department of Education have published on English language learners and sort of best practices in this area. It's incredibly long and incredibly detailed, but is very useful if people are trying to navigate some of the nuances here. Any questions about that issue before I highlight a few other major sources of resources for people?
Let's give it a second. I do have just something that I'm like curious about. I don't know if one of the advocates that work with immigrant farm workers will chime in over here with a question, but when you're thinking about like homelessness, when I think about homelessness within the immigrant farm worker population, and just how transient that population is, they're moving around a lot, and they're here for the season, and and just like the impact on their children, it's great. And so like does McKinney-Vento define like how long the period is, like if someone doesn't have fixed, I forgot what the other two.
Fixed, regular, and adequate?
Yeah.
No, McKinney-Vento doesn't define the length of time that a person has to, lack a fixed, adequate, or regular residence in order to qualify as homelessness. And, the federal government recognizes that there can be significant overlap in the population of students who are immigrants who are farm workers, or who are and who would also qualify as homeless. I don't think that the populations are identical. I don't think every farm worker family would necessarily qualify as homeless, but there is significant overlap, and it really is done on a case-by-case basis. But I'd encourage advocates and families to consider whether they would qualify under McKinney-Vento, and if so, to push for additional services there. There is also a federal law called the Migrant Education Act. I think I'm going to mess up the law, but it has at least those words in it. But that doesn't create individual rights for students. It provides funding and requires school districts to develop programming to support the unique needs of migrant students. So there may be programs in particular jurisdictions that have high populations of migrant farm workers that have, special education programming under that federal law designed for those students. Again, it doesn't entitle any individual kid to a particular program, but it's intended to help support districts in doing that work.
Okay, great. Awesome. And then we have a question over here. Can you give us an example of you or someone you know that has advocated for an immigrant farm worker, a story perhaps, what happened and what was the possibility there?
I don't have any stories to share on that issue personally. I do, I'm aware of systemic work that people have done in other jurisdictions and that other organizations in Washington State, Team Child and Columbia Legal Services, but I don't know those situations in enough detail to provide, personal stories.
That's
there.
Okay. And, one of the things, before I move on to the next question, one of the things that I'm just I'm left with in terms of, what your call to advocates is that, if there's one thing that we should be taking away from your presentation is it's so important for us as advocates to understand this material and then share it and help correct any misunderstanding with anybody, in terms of the rights of students and the rights of young people. And that could really make or break, someone's life, in
Yes.
terms of how they move forward through the system. And so, I just hear it so loud and clearly that our role as advocates is really understanding the system and helping, DVSA survivors or children impacted by DVNSA, just help them navigate through the system. It's a complex system, right? Yeah. And if all you're doing is surviving, then how can we just keep sharing this information, help correct understanding, and help navigate through the system? So that's one thing that I'm left with. And then one of the things that you did say is, joining our advocacy efforts with coalitions and organizations that are dealing with this issue. So we don't have to be the end-all, be-all of everything, but how can we basically, when we see something or when we hear something, how can we partner with Columbia Legal Services or Northwest Justice Project or the ACLU in bringing these stories forward so that they don't go unheard, And so those are the two things that I'm just left with. And then we have one more comment, which is, it seems like when there are problems with any of the things that you've outlined, taking legal action concurrent with community engagement or raising the profile via demonstrations or social media can be a winning strategy. Have you seen examples of this?
Yes, that is actually the sort of ACLU model of how we do our work, which is a mixture of legal action, community engagement, and trying to bring attention and educate others on this issue, not just the people who are impacted, but also broader social movements. So one, very clear example of that's going on in King County right now is the work that folks are doing around decreasing the numbers of young people in juvenile detention, right? And that's a movement that's being really led by community-based activists and advocates who are pushing for community engagement, increased media attention to these issues, lobbying for legislative change and budget amendments, and also taking additional legal action that way. So I do think that all of these issues are ones that benefit really from a big integrated strategy. And in terms of the question that you asked about how to reach out to other organizations that are working on these issues, I'll flag for you a few additional resources, and then I'm happy to help facilitate those conversations wherever helpful. So the ACLU has a ton of public education guides on these issues. We have, and all of these are available on our website at this teacher resources. We have one on student rights and responsibilities in the digital age, one generally on know your rights in public schools in Washington that focuses on student speech and suspension and expulsion and bullying and all sorts of other things. We have a parent's guide to school discipline, a parent's guide to truancy, a parent's guide to school board advocacy, a guide to gender equity in athletics, and a guide on transgender people in Washington state that also includes information about students in schools particularly. The State Office of Superintendent of Public Instruction has an equity and civil rights division that has really specific guidance. There's literally an A to Z on just about everything you can imagine. So they have interpretation and translation services, discipline, disability, athletics, bullying, you name it. They have a page on it that collects lots and lots of resources. And OSPI, as the government agency that oversees schools, also has enforcement powers. So they have the ability to investigate and ensure compliance in districts with civil rights laws. There's also the Office of Education Ombuds, which is actually a division of the governor's office, and the OEO, the ombuds, acts as sort of like a mediator with families that are having troubles with schools. So people can get in touch, or advocates can get in touch with OEO. OEO acts sort of as a bridge or an in to the district, and they have really helpful resources in both English and Spanish on a whole bunch of issues, including students with disabilities, discipline in schools, and how to be an advocate in education for students and families. In addition to that, Team Child provides comprehensive legal services and advocacy to kids all around the country in the areas of school discipline and education and juvenile justice. The Columbia Legal Services also provides educational advocacy, and then the Northwest Justice Project has a number of attorneys who work on education and juvenile justice issues all throughout the country. So any of those organizations are ones that people can reach out to. And what's nice about Washington is all of the legal advocates really try very hard to coordinate our work and be supportive of each other. So while we don't all work on every single issue, we try to make sure that we're allocating our resources, efficiently and smartly, and that we're supporting each other when, it's helpful to have all of us on an issue. So any of those organizations can point you towards the best resources for the particular problem that you're having. And folks are always welcome to get in touch with me directly if they'd like a little more information or some additional resources and referrals.
Awesome. And the ACLU guides that you just listed, are those available in Spanish as well on your website?
I believe some of them are, not all of them are.
Okay.
We're working on getting some of them translated, others of them translated, but many of the other organizations have guides in English and Spanish as well.
Okay, great. Awesome. Are there any last minute questions or comments or anything that people want to say before we sign off over here? I'll give you a couple of minutes to do that while we still have Vanessa live in person. But this was like a fantastic discussion. I really just enjoyed learning again. Like, it's so funny. We talked about this for a couple of weeks, and I'm sitting here still learning it again, so it definitely takes more than once to like grasp all the information. And for those of you who are on this webinar, there is on your control panel, there is a handout section. And if you just click on that link, you should be able to download the handout and save it onto your hard drive. We knew that this PowerPoint is really easy to read and refer to later. So please download that handout if you haven't done that already. And then we will work with Vanessa to see if we can get some of the model policies and guidelines out that she has been referring to. And then we'll go from there. I don't see any other questions over here. So thank you so much, Vanessa, for working with us. Thank you for coming over. We really enjoyed having you here. And if there's anything that like you hear of, we'll let you know or let us know, and vice versa.
And thank you all for participating. I really appreciate it. And thank you all for the work that you do as well.
Thank you. Okay, bye-bye everyone, and thank you for being here.